Please rise. The Honorable Justices of the Supreme Court for the State of Alaska.
Please be seated.
The Supreme Court is now in session.
Good afternoon. This is the time set for oral arguments in Meade Treadwell, Lieutenant Governor of the State of Alaska versus Alaska Fisheries Conservation Alliance. Chief Justice Stowers is ill today. He was not able to attend. I understand it is his intent to listen to or watch the oral argument as soon as he can, and then we will confer on the matter after he has done so. And of course, as you always know, that we'll issue an opinion in due course after that. But that's why you see me in the center today instead of Chief Justice Stowers. So, our counsel ready?
May it please the Court, I'm Joanne Grace and I represent the Lieutenant Governor. I'd like to reserve 5 minutes for rebuttal, and I am giving 6 minutes to the amicus resources for all Alaskans. The initiative before the Court will eliminate the Setnet fishery in Cook Inlet. It should not appear on the ballot because if it's enacted, it will appropriate Cook Inlet salmon and thus will violate the Alaska Constitution's prohibition on making appropriations through the initiative process. The Court has a two-part test to determine whether a proposed initiative makes an appropriation. First, the Court determines whether the initiative involves state assets. In Pullen, the Court determined that salmon are state assets for this purpose. The second step is to determine whether the initiative would appropriate those assets, and that's the question before the Court today. In its initiative cases, the Court has examined the second part of this question by considering whether the initiative would undermine the two core objectives of the constitutional delegates in making the prohibition on appropriation through initiative. The first core objective is to prevent giveaway programs that appeal to the self-interest of voters at the expense of state treasury or vital state activities. The second core objective is to preserve legislative discretion by ensuring that the legislature, and only the legislature, controls the allocation of state assets among competing uses. The Setnet ban initiative violates both of these core objectives. I'd like to start with the second. The Setnet ban initiative makes an appropriation because it inhibits the board's ability to allocate Cook Inlet salmon among competing needs. In Poland, the Court found that because in times of shortages, the fish initiative there would allocate fish away from certain commercial fisheries, it designated the use of state assets and therefore made an appropriation. The Setnet ban initiative also allocates fish away from a particular commercial fishery, and therefore Poland controls this case. The Superior Court adopted AFCA's argument that Poland is distinguishable because in Poland, the fish initiative impeded the board's ability to allocate fish to particular commercial fisheries when certain stocks were in short supply and didn't allow the board to allocate to other commercial fisheries, allocate those salmon to other commercial fisheries, while the Setnet ban initiative impedes the board's ability to allocate salmon to one particular commercial fishery, but still allows it to allocate to any other commercial fishery. In essence, the distinction they made is that the Setnet ban does not prohibit the board from allocating to other user groups within the same broad majority user category. But the emphasis that AFCA places on these majority user groups ignores the standard that the Court actually applies to determine whether an initiative violates the second core objective, and that is whether it impedes the board's ability to allocate fish among competing uses. To define competing uses as occurring only among these major user groups, sports, commercial, personal use, and subsistence fisheries, places form over substance in a way that's contrary to the way this Court ever has looked at the impact of initiatives. The Court has taken instead a very practical approach to see what the actual impacts are on these core objectives. The definition places form over substance because, in fact, the Setnet fishery in Cook Inlet competes with sport, personal use, and the drift net fishery. These are fiercely competing uses, and the Setnet initiative would allow voters to simply eliminate the competition from the Setnet fishery. The majority user group distinction that AFCA makes is an artificial limitation that does not mesh with the board's actual authority, and it does not mesh with the actual competing uses in Cook Inlet. Superior Court and AFCA also oversimplify the analysis by taking the position that any gear ban, any initiative that simply bans a gear type, is mere regulation instead of appropriation. That also ignores the actual standard of the court, and it also ignores reality. This court has found that the line between mere regulation and appropriation is drawn, the line is drawn where, in the Staudenmauer case, the court said that the difference between an unobjectionable regulation that simply regulates state assets and an impermissible appropriation is drawn where the voters simply have usurped the legislature's authority to allocate among competing uses. So whether a gear ban is mere regulation or an appropriation depends on whether it interferes with the board's ability to allocate among competing uses. That depends on whether it eliminates competing uses. So some gear bans are not going to eliminate competing uses. Superior Court gave the example of a fly rod versus a spin rod and said that does not represent two distinct groups. And that's probably correct, because an initiative that banned a fly rod would not disturb the board's allocation among competing uses, because the same fishermen are going to fish for the same fish in the same area in substantially the same way. They're just going to use a different kind of rod.
What about an initiative that barred all rods?
The initiative that barred all rods would probably fall closer to the appropriation, because part of the analysis or the line, because it would in effect impede the board's ability to allocate among competing uses. It would depend a little bit on the actual circumstances, but the question is, how can you, if there's a sports fishery that allows rods and rods are eliminated, there's nothing that can substitute in for that. It would essentially eliminate that competing use of sport fishing. And the same is the other example that I'd like to give of one that doesn't impact allocation is an initiative that bans wolf snares, because that wouldn't impede the game board's ability to allocate game among competing uses, because the same trappers would likely trap the same wolf populations along the same trap lines. They would just use a spring lock trap or some other kind of trap instead of a snare. But when the gear ban in effect eliminates a competing use, then the initiative falls on the appropriation line. And that's what the Setnet ban does, because it effectively eliminates the fishery.
How do you answer the argument, and I may not be phrasing this exactly the same way, but the argument that the sponsors make that this isn't necessarily an allocation, because especially if you eliminate the fishers that are close to the bank, the set netters, some of those fish will just swim by. Some of those fish will not be caught by the drift gill netters, and predictably would not be caught by sport or personal use fishers. So it really isn't an allocation between those groups.
But what the initiative does is the board has allocated a salmon to the Setnet fishery and to the sport fishery and to the personal use fishery and to the drift net fishery. So eliminating the Setnet fishery means that it eliminates the board's ability to allocate any fish to the Setnet fishery at all. So that eliminating that fishery impedes the board's ability to allocate fish among competing uses. And the Setnet fishery is a distinct fishery. They couldn't simply just substitute in some other kind of equipment for Setnets. And in addition, Setnet fishermen have very valuable limited entry permits that are only applicable to Setnet fishing. And some of them have shore leases that are only usable for Setnet fishing. So this is a gear ban, but it's a gear ban that would in fact eliminate a competing use, and therefore it would interfere with the board's ability to allocate any fish at all to that fishery, and it would therefore make an appropriation. The Setnet ban initiative also violates the first core objective because it appeals to the self-interest of voters.
Before we get into that aspect of the prong, I mean, because this is all about line drawing, I'm sure everybody's tried to come up with some hypotheticals to find out where the lines can be drawn, but could an initiative say, boats pollute the Kenai River, and now we're going to ban all commercial fishing boats on the Kenai River? Did you do that? Would that affect an allocation?
I don't know that it would affect an allocation. That the board allocates to particular fisheries. So, I mean, I think if the initiative said a particular commercial fishery on the Kenai River that was a competing use with other fisheries, that would be an appropriation as opposed to mere regulation. But if in fact there's, I don't know all the fisheries in the Kenai River, but if there's sport fisheries and commercial fisheries that could continue without boats, then it would be a regulation instead of appropriation. In other words, it's a regulation until it interferes with the board's ability to allocate fish among competing uses. Don't know exactly where boats fall into competing uses, but it would depend on the particular fisheries that were impacted. If that led to the elimination of a particular kind of fishery, or even, I would say, substantial reduction of a particular fishery, then that would cross the line into an appropriation. But clearly, a gear ban that eliminates a competing use is a bright line that has gone from the regulation into appropriation. The Setnet ban initiative also violates the first core objective because it would have popular appeal, because it will accomplish what the sports fishing interests have been trying to do through the legislative and regulatory process, and that is to eliminate the competition from the Setnet fisheries. Superior Court found that the Setnet initiative would not appeal to the voters because in the Superior Court's view, an initiative does not do that unless it specifically targets a particular group or entity to receive the assets. This analysis is wrong for two reasons. First of all, that's never been part of the court's analysis of the first core objective. The trial court used the Pullen case as an example of an initiative that targeted a particular groups to receive the benefits of the initiative, and that happens to be what the fish initiative there did. It gave a priority to sport, personal use, and subsistence fisheries over commercial fisheries, and that's the way it was written. It didn't say priority for all uses except commercial uses. It said a priority for subsistence, personal use, and sport fishing. But the court didn't indicate in the Pullen case that that was critical to the analysis. It's never said that. And in fact, in the Alaska Conservative Political Action Committee case, the court invalidated under the first core objective an initiative that would have required the municipality of Anchorage to sell a utility for $1, even though neither the initiative nor the opinion specified at all who would benefit from that. That wasn't part of the court's analysis. Superior Court's analysis is also wrong because it raises form over substance, again in a way that this court has never done when it examines the impacts of initiatives. Concluding that sport, personal use, and drift net fishers would not view this initiative as being in their own interest is simply to ignore reality. It ignores reality because, by definition, a Setnet ban is going to increase the amount of fish available for those other uses. and that would appeal to the self-interest of the voters. That's definitely how the media has interpreted this initiative, as indicated in the briefs of the state and the amicus, and that's probably how the voters would understand it too. And the fact that this is how sport fishing interests view this initiative is illustrated by the statement of one of AFCA's board members to state legislators, saying that elimination of the Setnet fishery in Cook Inlet will end the fish wars there and will give the public a fairer share of the salmon stock. And the Setnetters are greatly outnumbered by personal use sport and drift net fishers. There are about 740 Setnet permits in Cook Inlet, only about 2/3 of which are actively fished, but there are 250,000 sports fishermen in Cook Inlet, and the Kenai River and Kasilof River personal use permits number in the tens of thousands. And the Setnet ban would harm vital government interests. In particular, it would complicate management of mixed stock salmon in Cook Inlet. Managing mixed stocks can be difficult when healthy stocks of salmon intermingle with less healthy stocks, because the board has to engage in a delicate balancing act to try to restrict harvest of the less healthy stocks while trying to allow harvest of the abundant stocks. In eliminating the Setnet fishery in Cook Inlet would lead to overescapement of sockeye salmon, and that would jeopardize the continued health and stability of that species, and the sockeye salmon could not simply be caught by the drift net fishery because the salmon sometimes swim too close to shore for the drift net fishery to catch them.
The management issue seems to me to inferentially, at least, point to the issue that was raised in Poland but not decided, about whether, because management of the resources is a public trust kind of arrangement, that you cannot by initiative tell the trustee what to do. And the court said it didn't have to decide that question in Poland, although then Chief Justice Compton said that that's the way he would have ruled. Why isn't that argument, if you can tell me, why, conspicuous by its absence is that argument in this kind of a case? And it seems like when the allocations are on a fine line like this and involve both management, doesn't that invoke that question?
I think that question, though, is inextricably tied to the question of whether the initiative would impact the board's ability to allocate among competing needs, because eliminating the Setnet fishery directly interferes with the board's ability to do that in Cook Inlet in a way that hinders its management. So I think the court could decide it could still handle the public trust question simply by deciding it that it violates the second core objective by essentially interfering with the allocation is part of the way the state manages for conservation and sustained yield. In other words, it's using the Setnet fishery as one of its management tools, and so I just don't see even how you can disentangle those two things. Because it infringes on the board's ability to allocate among competing needs, and that's in part how the state manages, then to the extent there is a public trust that initiatives can't upset, it would do that as well. I have information for the court. This initiative has been certified for the ballot, so I have the deadlines for ballot printing to the extent that that impacts the court's timeline for making a decision.
May or may not, but you can certainly tell them.
May or may not. It depends.
Make no guarantees.
No, I'm just in case the court wants to know. It depends on when it's going to go. It goes on the first general election ballot more than 120 days after the legislature adjourns. So it depends a little bit on when the legislature adjourns. If it goes on the primary ballot, the ballot will be certified for the printer on June 28th, 2016. If it goes on the general ballot, the ballot will be certified for the printer on September 7th, 2016.
Thank you.
All right, I'm going to
Thank you.
reserve the rest of my time.
Thank you, Bill Falsey for Resources for All Alaskans Incorporated. This is a case in which proponents of an initiative seek to eliminate allocations of fish to a rival class of users by banning setnets in the Kenai Peninsula, but not Seldovia, in Valdez, but not Prince William Sound, in Juneau, but not Bristol Bay. Resources for All Alaskans appears before the court today, first to confirm, to the extent that any confirmation is necessary, that commercial setnetters, a group that includes over 600 Alaska-owned and many multi-generational family businesses, are a distinct user group for purposes of fishery allocations. And second, to note that in addition to violating the appropriations ban, the initiative unconstitutionally proposes to enact local and special legislation as well. As this court has said, targeted legislation that is not of statewide or general application must have some unique statewide importance that justifies its geographical limitations. So this court thus is invited in this case to assess what unique statewide importance or subject matter of common interest to the whole state justifies legislation that would ban setnets in Anchorage, Juneau, Ketchikan, Fairbanks, and Valdez, but not most of the state's setnet sites or areas where conservation crises are more numerous and potentially more acute. The answer is nothing. A ban on setnets limited only to non-subsistence areas, which are defined in law solely as places where subsistence is not a principal characteristic of the economy and culture and way of life, is entirely arbitrary and irrational.
Let me ask you how you respond to the argument then that in urban areas, and particularly the Kenai River, that the area is particularly subject to pressure from sport fishermen and personal use fishermen because of the high population.
I'd be happy to get into that. The preview of the answer is that all of these fisheries across the state are, so on the salmon side, fully allocated. So the pressure is maximized everywhere, and by regulation, it has been equalized. So it may be that there are more people waiting in the wings to come down from the Anchorage areas, but where the nets hit the river, where the fish are actually taken out, the pressure is actually already the same. And that is not going to be a rationally distinguishing characteristic. I'd intended to begin with the appropriations argument. Happy to switch into this one, but if not, I'll return to appropriations and mop that up to say I don't intend to add to the state's argumentation here other than to say that I think it really is an open question whether the formal judicial declaration of a user group matters in this case, because the tests that have always governed this issue have looked at whether discretion is retained in the legislature to allocate among competing needs. Certainly commercial setnet users do have competing needs, but this case may actually be even easier than all the fraught hypotheticals that have come in through the briefing and that may come in from the panel, because as a matter of law, commercial setnetters are treated differently by the Commercial Fisheries Entry Commission for purposes of licensing, by the Board of Fish for making allocations, and the Board of Fish has codified in regulation its understanding that commercial setnetters are a distinct user group, and by the legislature, which has enacted a special regime of shore leases solely for setnets, which presumes that the commercial setnet fisheries are going to continue to receive allocations. And if part of the reason the ban on appropriations in initiatives exists is to retain discretion in the legislature, certainly it should matter to the court's analysis that the legislature's delegates and the legislature itself appear to have concluded that commercial setnetters are a distinct user group. And I will say the court has itself indicated that it is capable of policing this line. I'll draw your attention to a case that was not cited in the briefing, Alaska Fish Spotters, in which the court found that it was permissible to ban the use of spotting fish biplane in the Bristol Bay area, but a use that was not permitted by the CFEC or used for purposes of allocation by the Board of Fish. And there the court dropped a footnote and said, even in that context, if the board bans fish spotting for the purposes of allocating the resources between competing subgroups of commercial uses, it's an allocation and it must comply with AS 1605-251E. So turning then to the issue of the larger local and special legislation, the court is...
So why wasn't that cited in any of the briefs?
Well, because that actually derives from the equal access clauses line of cases, and I will candidly confess that the notice of supplemental authority was the first thing that put me on to that. But I will apologize. I'll say it is 838 P. 2nd 798. I think it's helpful to the court, although not critical to resolution of the issue. On the local and special legislation issue, where
just ask a procedural question about that before you get too far into
Yes.
it. It's the appellee's position that you, as an amicus, are not allowed to present an argument that wasn't presented by the state in rejecting the initiative and wasn't presented by the state in the trial court or on appeal. What's your response?
So we think the argument is in the case for procedural reasons and for substantive reasons. First, procedurally, it was appropriately raised below and reached by the Superior Court. Second, that it is encompassed within the statement of points on appeal, which say both that it violates the appropriations ban and the subject matter restrictions of Article 11, and because the way the Superior Court addressed this issue was tantamount to a finding that it was appropriate for an amicus party to raise, and AFCA hasn't objected to or appealed that. But substantively, the notions of fairness and judicial economy really do push heavily in favor of resolving all challenges to a ballot initiative in a single expedited proceeding. And here, there was no case for all Alaskans to file. We had not been aggrieved by the Lieutenant Governor's determination. And in accordance with this court's guidance in State v. Widener and elsewhere, when the choice is between an amicus participation or an intervention, we waver heavily in favor of amicus so that we aren't asking to depose people or making extraneous motions. And in this case, we appeared and said that we want to be here solely to put this argument in play. And the first moment there was any objection, we said, we'll intervene if that's what it takes. The court said no, but still reached the issue, which was exactly the procedural resolution that we wanted. So we think the argument is in the case. I'm running pretty short on time, but I'll say on the first step, it is true when looking at whether the law is of general or statewide applicability that this would apply to all non-subsistence areas anywhere in the state that exists now or may exist in the future. And AFCA argues that that alone should short-circuit all judicial scrutiny of its basic rationality. But that can't be correct for three reasons. First, because it would make our clause totally unlike every other jurisdiction's, which we know was not the original intent. And second, because it would be an invitation to mischief. And here you could imagine an alternative counterfactual in which an initiative was proposed. It was forthrightly entitled, an act to do something totally arbitrary and unrelated to non-subsistence areas, solely within non-subsistence areas. If judicial scrutiny ended on the observation that it would apply to all non-subsistence areas, the clause wouldn't be doing much of any work, and certainly it would reduce the clause to something like a rule about special pleading or artful drafting, because you could always cobble together a targeted geographic effect by inventing some new class. But most importantly, we know it's not right because this court has said that the critical question is whether the subject matter of the initiative is of common interest to the whole state. And on this question, the man on the street will know why we have a common interest in where the state capital should be, or whether their borough assembly should approve sales taxes within the borough. But they'll be totally dumbstruck, like the court was in the Eagle River, Chugiak Borough Abrams case, to puzzle out what the common interest is here. Fundamentally, AFCA cannot be free to hijack a politically convenient non-subsistence area category, point to its statewide character, and then end the analysis there. That's exactly what the local and special legislation clause was designed to prevent: favorable legislation in your own backyard.
Okay, Mr. Falzo, you've used up all your time.
I've used up all my time. Well, thank you, Your Honor.
You can take a minute to wrap up.
Well, I will wrap up then by saying...
Nothing new, just wrap up.
Nothing new. I will say there is no racially distinguishing characteristic. This is not an incremental ban. It is an arbitrary ban. 13 PCA unconstitutionally proposes local and special legislation, and we support the state and its appropriation arguments.
Thank you. Mr. Singer.
Good morning. May it please the court. I'm Matt Singer for the appellee Alaska Fisheries Conservation Alliance. Sitting right behind me is Joe Connors, who's the president of AFCA. As Justice Winfrey observed, the court is here today to draw a line, specifically where to draw the line between allowable natural resource regulation and an improper appropriation under Article 11, Section 7 of the Constitution. We think that the court's already drawn that line with its prior precedent. I'd like to begin, and I think the analysis should begin, with the definition of an appropriation, a definition that was omitted from the argument that the court just heard and omitted from the opening brief of the appellant, but should be dispositive of this case. After I discuss the definition of an appropriation, I'll then turn to this court's specific holdings with regard to ballot initiatives that deal with natural resources, most recently in Hughes v. Treadwell, and before that in the Pebble versus Parnell case, because those two cases should answer the court's question today. Third, I'll address the two core objectives that were discussed by counsel for the Lieutenant Governor. Fourth, I'd like to briefly touch on Alaska's long history that goes to statehood of voters going to the voting booth to weigh in on questions about the methods and means for take of wildlife and fish. This is part of who we are as a state. This is part of how Alaskans exercise their democratic rights. And fifth, if time permits, I'll briefly touch on Mr. Falsey's special legislation argument. To begin, the analysis should start with a definition of an appropriation, because this court has a long-standing standardized definition that it's applied since the Fairbanks Convention Center case over 25 years ago. An appropriation is a set-aside of a certain specified amount of money or property for a specific purpose in a manner that is executable, mandatory, and reasonably definite with no further legislative action. Prohibiting one method for the commercial take of fish is not an appropriation. It does not meet the definition. The reason is because it does not affect an allocation in a manner that is executable, mandatory, and reasonably definite.
So you could, by initiative then, you could ban set nets, drift nets, seine, fish wheels, and the argument would be you can just allocate as many fish as you want to those commercial fishermen. They just can't use any of those means of catching them.
Well, the test the court adopted in Hughes v. Treadwell and in the Pebble case.
It's really a yes or no question. Then you.
Well, I'm not sure I can answer it. I think that the answer is it depends, and it depends on the application of this court's test. This court's test in Pebble.
The way you interpret this court's test.
Well, I could just state the court's test. The test is
under the way that you have interpreted our court's test. Could you ban by initiative set nets, drift nets, seines, fish wheels, and all other kinds of commercial fishing gear, and say that's not an allocation because you can go catch them with your bare hands or you can go catch them with a fishing rod? We're just regulating the gear type. Can you do that?
I think the answer would be no, that the court would say no. If an initiative proposed to ban all methods of commercial fish.
I didn't say all methods. I left open fishing poles, bare hands.
I'm sorry, I heard the question. I heard Your Honor to say all other methods of commercial harvest.
Maybe I used those words, but I'll back off from that and say all but fishing poles, all but this or all but that. Can you do that?
The court has to draw a line somewhere. And if we take it to the extreme, which is the example that Your Honor has offered, at some point where you usurp the legislature's ability to allocate resources, this court says that's not permissible.
Why would
we don't get anywhere close to that?
Until the last step as opposed to the first step of usurpation of the legislature's power?
Because this court has recognized that voters have a constitutional right to exercise direct democracy. And so this court has said that voters are permitted to consider initiatives that regulate natural resources. Voters are permitted to consider initiatives that affect allocations. Voters are permitted to consider initiatives that create beneficiaries and that create losers. What voters cannot do is entirely usurp the legislature's ability to allocate a resource. What the court said in the Pebble case and then again in the Hughes v. Treadwell case was that an initiative that places a constraint on natural resources is allowable so long as the initiative does not take an asset entirely away from one group and give it to another. We don't get anywhere close.
Wasn't that statement made in the context of explaining the Pullen case, a case in which the court found an appropriation in favor of 3 user groups?
A case that dealt with an initiative that had an express harvest preference for user groups. So in the Poland case, the initiative didn't regulate a method or means for take, but instead established a harvest preference that the sport fishermen and the personal use fishermen, they get their harvest first. They get their allocation first, and the commercial fishermen have to stand in line. Nothing like that occurs with 13 PCAF. Rather, one outdated method of harvesting fish is prohibited, and the Board of Fisheries remains able to allocate fish among commercial and sport and personal use fishermen as it sees fit. Nothing about this initiative provides that one more fish ends up on a fly fisherman's pole or in a dip net or in a personal use fishery. This initiative simply regulates one method of take, just like the aerial hunting initiative did, just like the wolf snaring initiative did, just like the bear baiting initiative did, just like the fish trap initiative ordinance did at statehood.
So the definition of appropriation that you're relying on, does that explain the result in Poland?
The Poland case took an asset and specifically allocated it to one user group or two user groups.
3 user groups.
Sport, personal use, and subsistence fishermen got a preference. And everyone agreed that in times of where the runs were limited, that initiative meant the commercial fishermen would be closed. There would be no commercial fishing. So there was an express allocation. It's the equivalent of saying we have, that it would be equivalent of an initiative that requires a percentage of the general fund be spent for a specific purpose. That would impair.
But isn't the effect much less drastic? At least the initiative in Poland, the Setnet fishermen could say, I might be able to fish this year. If this initiative passes that your sponsors advocate, then the Setnet fishermen would be able to say, I won't be able to fish again.
That's not correct.
I mean, isn't it, if you look at it from the Setnet fisherman's point of view, it certainly is an allocation.
Well, certainly, but we're not here to decide the Setnetters' point of view. And the Setnetters, under the Fish and Wildlife Fund, the case that the court decided this year, no specific gear type has any sort of special right or constitutional right to catch fish using that gear type. The Setnetters
are...
are...
agree that a gear ban that eliminates a potential user group, a commercial fishery entirely, would be an allocation?
A ban on all commercial fishing would be an allocation. But set netting is not. Set netting is one method by which commercial fishing is done in the state of Alaska.
But your argument depends on the likelihood that there would be other means and methods for commercial fishing besides set netting.
Yeah, it's more than a likelihood. We know that there are other methods and means. In 2012, the state, in order to conserve king salmon on the Kenai River, it closed the Setnet fishery. The Board of Fisheries did not allocate more fish to sport fishermen, did not allocate more fish to dip netters, but instead increased the hours and times for the drift fleet. So the commercial harvest that had been established by the Board of Fisheries was caught by the commercial fleet. So an individual set netter, as a result of this initiative, will no longer be able to use his set net, but he can go and catch fish with a drift net. Or the Board of Fisheries could establish a new fishery. There's commercial dip netting that's being experimented with in the state of Alaska. There's beach seining. There are a number of other fish wheels. There's a number of other techniques for catching fish. Those were identified in Randy Bailey's affidavit at Excerpt 40, and the trial court recognized, just as a sport fisherman could use a fly pole or could use a rod and reel, there are multiple ways to catch fish. This court...
Well, I have a question for you on that argument, and I apologize, but it's kind of a long question. The question really is whether that argument just ignores the whole historical regulation of this fishery, and particularly the institution of limited entry. And you know, we had litigation that led to a constitutional amendment to allow limited entry. At that point, the legislature created an agency, the Commercial Fisheries Entry Commission, that looked carefully at each fishery and how to divide them and how to decide which fisheries were distressed fisheries. It identified 19 distressed fisheries initially and set up a point system to adjudicate who would be entitled to fish in these fisheries based on past participation and economic dependence. The adjudicatory system was monumental. It took over 30 years to adjudicate all of the permits, even in those initial distressed fisheries. And I believe that, I don't know, 8 more salmon fisheries have been added since that time. And so my point is, and of course, the Commercial Fisheries Entry Commission decided to designate the fisheries by gear type. And so my point is, after all of this history, and all of this adjudication and the legal difficulty of going through this, how can you argue that the elimination of one of these designated fisheries is not an allocation?
Again, because it is just one method of harvesting fish. This court just said in the Alaska Fish and Wildlife Fund case that there's we consistently define user groups in terms of the nature of the resource, fish or wildlife, and the nature of the use, i.e. commercial, sport, or subsistence. And the court said that under the equal access clauses of Article 8, exclusive or special privileges to take fish and wildlife are prohibited.
That, of course, is the clause that is accepted for the purposes of limited entry. In other words, the limited entry permit fisheries are not impacted. Discriminations between the limited entry permits are not, fisheries are not impacted by that clause.
But going to Your Honor's question, again, the user groups in Alaska are the commercial fishermen, they are the sport fishermen, they're the subsistence users, and the personal use users. And altering one outdated, indiscriminate method for harvesting fish commercially while still allowing a robust commercial fishery is not an allocation. We know that from experience, from what happened in 2012, that the setnets remained on the beach and that the commercial fishery met its harvest requirements. Again, what this court has said is that a natural resource initiative can affect the allocation process. It could, in the Hughes v. Treadwell case, the court observed that the initiative might benefit the fishing industry at the expense of the mining industry. But because it did not take an asset entirely from one group and give it to another, it did not affect an appropriation. This initiative doesn't affect an appropriation because even though it takes fish out of set nets, it leaves for the Board of Fisheries ample opportunity to allocate those fish to other commercial means that are readily available.
Is that really true as a practical matter, though? When you're taking 700 units of gear, or someone said 600 today, you're taking, for short periods, the board can do that in terms of its allocative responsibilities. But then you have a limited number of drift gill nets. Is it really true that that is not an allocation?
Yes, there is nothing about set netting that is so integral or important to commercial fishing that we can't do without it. Set netting's been, these nets have been banned.
I didn't ask that very carefully. What I was really meant to ask is it really true that the board's authority could be exercised effectively with only these 500 or so drift gill net permits that are left in Cook Inlet?
Well, absolutely. And first, the question here is ultimately what discretion is left to the legislature. So we start with the legislature's discretion, and then the Board of Fisheries is a delegee of the legislature. But But there's nothing preventing the creation of new fisheries. That can be done. The law may have to be amended to do it, but the legislature can amend the law. The setnets have been banned in coastal states throughout America. According to the amicus, setnets aren't used in many places in Alaska. They're used for historical reasons and for convenience in certain parts of the state.
Those bans that you mentioned in your brief, are those just set nets or are those all gill nets that are banned in those states?
Well, it depends on the states. So, but there have been several bans on the use of shore gill nets. But the conservation concern is with indiscriminate methods of harvest. So there have developed, and this is discussed in Randy Bailey's affidavit, there have developed methods of harvest that allow the fishermen to discriminate and to remove and throw back live non-target species. Setnets, the problem with setnets is every species that hits a setnet is killed.
Is there a distinction with respect to that problem between set nets and drift gill nets?
Well, the significance is that, and again, this is discussed at the affidavit at Excerpt 40, the drift gill netters are better able to differentiate both vertically and horizontally. So different species swim at different elevations in the water, and they swim in different spots in relation to the beach. So drift netters have much less bycatch than do set nets. That is, they're able to target species more effectively. That's why they are a preferred method. Let me turn briefly to the two core objectives that were discussed by the Lieutenant Governor. The first core objective deals with giveaway programs. Poland involved a giveaway in that there was a specific preference established by the initiative. You don't have that with a regulation on a method of take because again, this initiative doesn't, in an executable and mandatory and definite way, this initiative doesn't guarantee anyone an additional fish. The Board of Fisheries could continue to
Guarantees somebody, doesn't it?
Well, again, if we get back to how do you define a user group? So
Isn't that really the gut of the case?
it's an integral part of the case, Your Honor. It's an integral part of the case.
User groups are either A, B, C, D, or they are sub-fisheries and by gear, right?
Yes, and there's a significant problem if you start to define user groups for purposes of this constitutional analysis by looking only at the object of the proposed regulation. So aerial hunters, those people who used airplanes to identify wolves and land and shoot them, if you identified them as a user group, then we took away that group's access to wildlife with the aerial wolf hunting ban. If you define as a user group large mines that discharge certain levels of pollutants, then the Pebble versus Parnell initiative would be appropriative in that it took away the ability to mine from those users. You can create
Our previous cases, though, talk about the fact that the board has the power to allocate, which I assume is the same as an appropriation to some extent, fish between different aspects of the commercial fishery. I mean, we've said that. They've got the authority to do that. We call it an allocation. So if you take one of those away, then isn't that, taking away an allocation?
I don't think that's consistent with this court's prior holdings, because this court, and the most recent pronouncement, again, is the decision this year in the Fish and Wildlife Fund case. This court says that the user groups, for purposes of constitutional analysis, are commercial, sport, personal use, and subsistence. So a reallocation or change in how you harvest fish within an intergroup allocation as opposed to an intra-group allocation, it is not an appropriation of assets. The concern here, we appreciate and understand the setnetter's perspective, but But Article 11, Section 7 isn't in the Constitution to protect individual interests. It's to protect the legislature's ability to allocate. And the legislature, or the Board of Fisheries' interest is in catching enough commercial fish to support the industry, to generate whatever revenue it wants to generate, to regulate the species for healthy returns, to allow sport fishing and personal use fishing and subsistence. The Board of Fish has plenty of tools left in its toolbox to achieve the state's interest, because there's all kinds of ways to catch fish commercially. And this one outdated, improper method can go without affecting the allocation among commercial, sport, and personal use fishermen. And
Could an initiative then ban setnet fishing statewide?
yes,
And so I suppose there's probably, there's at least 4,000 set gillnet permits. Those could just be wiped off the books. Bristol Bay, Kodiak, entirely.
I think given the other methods and means that exist, that it is likely. Now, I think you have to ask with each fishery, you have to analyze and apply the test that this court's adopted, which is, does it take away an asset entirely from one group and give it to another? So if there is a geographic spot where set nets are the only method of harvest, and removing those nets would mean there would be no fishing by one group, then that might be an appropriation. We don't get anywhere close to that here on this record, and as a matter of fact in law. This initiative leaves to the Board of Fish ample discretion to make appropriation decisions. There is no giveaway, so there's no violation of the first core objective. The state argues there may not be a giveaway, but this will appeal to every category of fishermen other than set netters, because they'll think there's more for them. Most initiatives appeal to the self-interest of some voters, so that the mere appeal of an initiative is not a concern. The concern is, does the initiative affect a giveaway? This one does not.
And as far as this issue goes, isn't this exactly the same incentive to voters as the initiative in Poland?
Absolutely not. The initiative in Poland expressly said that voters were adopting a preference for sport and personal use and subsistence. So the day after that initiative would be enacted, the Board of Fisheries would be directed as to percentages of harvest. It had to would have to implement the allocation as directed by the initiative. This initiative, if it's passed, the Board of Fisheries will have to evaluate, okay, set nets are no longer permitted in these places. What are we going to do with the allocation? But the Board of Fisheries could decide, we're going to increase the commercial harvest this year. We're going to do it with these methods. So there is nothing about this initiative that guarantees voters one more fish. And it's comparing apples and oranges to compare this initiative to the initiative in Poland. Let me touch briefly on our history of going to the polls to vote on the method and means for take a fish. Starting with Ordinance 3 in the Alaska Constitution, voters went to the polls to ban fish traps. And they did so for conservation reasons. Certainly, people who used fish traps to catch fish were no longer able to do so. I mean, just as set netters would no longer be able to do so. But the framers of our Constitution, they specifically considered, and this is discussed in the Brooks v. Wright case, they specifically considered, is this a question to put to voters, or should this be put to the first legislature? And by an overwhelming majority, they voted to put Ordinance 3 to the voters. So from the moment of statehood, at the very same time, Alaskans, before statehood.
And so the Constitution wasn't in effect at the time. It's kind of a different analysis, isn't it?
The point isn't that it's...
It may be the spirit of things, but it doesn't affect the legal analysis one bit, does it?
Well, I think that this court, in interpreting the Alaska Constitution, tries to be true to the framers' intent. And it's at least circumstantial evidence of the framers' intent that the first thing they did was to ask voters to ban a method for catching fish. We've been back to the polls numerous times to consider aerial wolf hunting, to consider wolf snares, to consider bear baiting, to consider various regulations on mining practices. And each one of those initiatives was evaluated by the Department of Law and certified by a lieutenant governor. So there was a process by which those initiatives, constitutional process by which those initiatives went to voters. What the lieutenant governor is asking
Does that
here,
mean that they were constitutional?
again, we have, the point here is simply this we have a long-standing history that goes back to the commencement of the state, and this would be a substantial departure and revision of our history to decide today that voters don't have a place at the ballot box to consider methods and means. I think this court in its decisions has recognized that this is about how we structure our democracy, how voters participate in our democracy. And our Constitution gives to voters a constitutional right to submit legislation for consideration. Doesn't mean that the initiative will be passed by voters, doesn't mean that the initiative is a good idea, but that my client has a right to submit the question for voter consideration, and that this court's role ought to be conservative, and that it ought to be protective of this constitutional right, just as it's protective of other constitutional rights. And what that means is, unless an initiative is clearly over the line, it should be for the voters to decide in the first instance.
Are there any examples of initiatives that have outlawed such a discrete and, I guess I would say, permanent arrangement similar to the interests of the setnetters in this case?
Well, I think that each of the wildlife initiatives that voters have considered, which I acknowledge have not been litigated, several of them.
But those wildlife cases, that's just year to year. Your license is just year to year, right? In the Setnet fishery, you can earn or purchase a license that is permanent, divisible, saleable.
Well, I think it's entirely plausible that there were guides who had established over many years an expertise and a business that involved aerial spotting of wildlife, that they sold that service, that they trained others in it, that they marketed to clients, that they had done it for years, and those people had to find a different way to go about hunting when the initiatives were passed. Fish trappers at the moment of statehood had to find another way to catch fish. So I think there is certainly a corollary in those past initiatives. I do acknowledge that not each of those initiatives came before this court for analysis.
You got most of your time with questions. Mr. Singh, you got about a minute left. You might want to take time to wrap up.
Well, I appreciate the court's questions today. My client seeks to exercise a basic democratic right to put this issue to voters for consideration and for public debate. It's really not for this court to decide if this initiative is good policy or bad policy, if it should be enacted, it should not be enacted. We're here only to decide if it meets the subject matter requirements of the Alaska Constitution. And a ban on one method for commercial harvest of fish that leaves all discretion to the Board of Fisheries is simply not an appropriation. The court should affirm the well-reasoned decision of Judge Easter and allow this matter to be considered by voters next year. Thank you.
Thank you, Mr. Singh. Ms. Grace?
I'd just like to respond to a couple of points. On the point of the definition of user group, first of all, I'd just like to point out that that's not part of the court's analysis. The analysis is whether the initiative constrains the ability of the board to allocate state assets among competing uses. Now, AFCA urges the court to follow the definition of user groups in the Alaska Fish and Wildlife Conservation case. That case, and those were the major user groups, that's how the court defined it there. That case involved equal access clauses. The equal access clauses are a limit on the legislature's power to pick and choose among users. So the more closely defined they are, the more constrained the legislature is. So if a user group in that context is defined to be purse seiners who use fish spotters, then purse seiners who use fish spotters are going to be entitled to equal access. But it's completely the opposite in the context of the initiative. The broader the definition of user groups, the more authority it takes away from the legislature. Because if you define competing uses as these majority user groups, it leaves open the possibility for the initiatives to pluck out competing uses within those majority user groups. And that was not the intention of the constitutional delegates. It's to protect the state treasury and vital state activities from the self-interest of voters. On the point of the definition of initiative that AFCA says the Lieutenant Governor has ignored, they really overstate this court's use of that standard. The court does cite that standard in the context of the second core objective, not at all in the context of the first. But the court has indicated that even an initiative that allocates assets away from a particular purpose is an appropriation. And the initiative doesn't even have to directly, the definition I'm talking about is that an initiative allocates a specified amount of money or property to a specific purpose in a way that's executable, mandatory, and reasonably certain without further legislative action. In the Alliance of Concerned Taxpayers, the initiative did not set aside a particular amount of money for a particular purpose. All it did was allow the voters in the future to veto a capital project that cost over $1 million. It wasn't a direct allocation, and it didn't set any assets aside without further legislative action. The same thing is true in Pullen. The initiative in Pullen simply created the possibility that in times of shortage, the board would have to identify, at its discretion, identify commercial fisheries that targeted stocks that were in short supply and allocate fish away from them. So that definition, the use of that definition has not been the starting point or the mainstay of this court's analysis. It's been the two core objectives. It's also not true that there's a democratic right to vote on means or methods. That's never been true. Again, the court's analysis is whether the regulation would affect the legislature's ability to allocate resources among competing needs. I see that I've used my time. In conclusion, the Lieutenant Governor asks the court to reverse the decision of the Superior Court and to order that this initiative not appear on the ballot.
Thank you, Ms. Grace. Our thanks to counsel for their excellent briefing and always excellent arguments. We don't often get a large attendance in the courtroom for cases, and I hope everyone recognizes that you've seen some of the best appellate advocacy that Alaska has to offer. And we thank you very much. And as I indicated before, Chief Justice Stowers will listen to or watch the oral argument in the near future. We will then confer and take it under advisement, and a written decision will follow, and maybe or maybe not within the deadlines that Ms. Grace indicated would be appropriate for the next election. Thank you very much. Thank you.
Order that transcript. Matt, we got to order that transcript at the end there.